Hello friends. Today we are going to discuss about psychiatrist as an expert witness in the court of law. I am Dr. Suresh Badadmat, professor of psychiatry, working at National Institute of Mental Health and Neurosciences, Bangalore. In this video, I'll be discussing about what is the definition of expert witness. If a psychiatrist becomes a expert witness, what are the things he should know? What are the general principles he should follow? What is the evidentiary value of his expert witness? How to draft a certificate for the court of law? Preparing for the court, especially for the summons, and how to respond in the court of law. I'll be discussing in this video. Let's understand what is expert witness. The judge cannot be expected to be an expert in all the field, especially where the subject matters involved in technical knowledge, science, or even in various aspects of mathematics and information technology. The judge may not be in a position to draw inference from the available facts. Hence, during the adjudication of any case, the court may need an expert opinion in a subject which requires special assistance. During the time, the court calls for an expert who is specialized in a specific area. In this regard, an important legislation, that is, expert evidence, is covered under the Section 45 to Section 51 of the Indian Evidence Act 1872. Although it is a very old law that was during the British time, it was specifically Section 45 covered the opinion of experts. Now currently, the new legislation has come. That is Bharatiya Sakshya Adhiniyam 2023. Under that, Section 39 discusses about opinion of experts. Now let's look into Section 45 of Indian Evidence Act or Section 39 of Bharatiya Sakshya Adhiniyam. When the court has to form an opinion upon a point of foreign law or of science or art, or as to the identity of a handwriting or finger impressions, the opinion of that point of person specially skilled in such foreign laws, science or art, or in a question as to the identity of handwriting or finger impression or relevant facts, such people are called as experts in the court of law. In simple word, an expert is someone who by his training and experience has acquired the ability to express an opinion that an ordinary witness does not possess that skill. The evidence of an expert is such evidence is based on his expertise and experience. Here, the opinion of a goldsmith, although he is not an educated person, by the virtue of working in that area, an important case, that is Abdul Rahman versus State of Mysore in 1972, the court wanted to know the purity of the gold. At the time, they called a goldsmith who is not educated, but he has spent majority of his life in goldsmith. That is his profession. In this landmark judgment, the court clearly said that the opinion of a goldsmith as to the purity of the gold in question was held to be relevant as the opinion of an expert, though he had no formal education or qualification. His only qualification was experience. In this regard, my dear friends, although you may not be a forensic psychiatrist, by the virtue of working in forensic psychiatry, working in prison mental health, working especially assisting in the court, by the virtue of that experience, you can be called as a forensic psychiatrist. That means it's not just an education. That is, whether you have done MD forensic psychiatry or else DM forensic psychiatry, it is, along with the qualification, If there is a good experience is there, then it will be considered as an expert witness. In this regard, I would like to discuss an important case law, that is Ramesh Chandra Agrawal versus Regency Hospital Limited in 2009. This is a landmark judgment by the Apex Court. Here, a 60-year-old male goes to the hospital of Regency, that is basically Regency Hospital, with back pain. Not only that, he had difficulty in walking, weakness in both the lower limbs, and muscle wasting. The hospital immediately did X-ray and also CT scan. It clearly showed dorsal cord compression at D4, D6 and a pot spine was diagnosed. The doctor requested that he has to be operated immediately. On the same day, he was operated, but unfortunately, the operation failed. After approximately 20 days down the line, reoperation was carried out. Unfortunately, his symptoms worsened. Later, a third operation was done based upon the expert opinion. Although there was a mild improvement, the patient developed paraparesis, that is, both the lower limbs stopped working. In this regard, the patient went to Supreme Court because he lost in the consumer forum. And he appealed to the Supreme Court asking that National Consumer Forum did not take expert opinion. Hence, he requested the court to hear the case and give justice. In this case, the Supreme Court clearly said that the expert is not acting as a judge or a jury. Hence, he has to be given an opportunity so that the expert witnesses will give opinion regarding this case because he has undergone 3 operations. Further, in the same case, the court said that an expert has to show that he has made a special study of the subject or acquired a special experience therein, or in other words, that he is skilled and has adequate knowledge of the subject. In the case, the National Consumer Forum failed to get the expert opinion. Hence, my dear friends, in many a time, the court may request for expert opinion. Now the question is, when should the court should ask for expert opinion? That's an important question. The first and the foremost, the requirement for expert evidence to be admissible is that it is necessary to hear the expert evidence. The test is that the matter, that is a scientific question involved, is outside the knowledge and experience of the layperson or the court. During that time, the court may call for expert witness. Thus, there is a need to hear an expert opinion whenever the medical issue is involved, especially criminal negligence. Many times, even in the civil negligence, expert witnesses will be called. Hence, expert witness means by the virtue of education, profession, publication, that is research publication or experience, is believed to have a special knowledge of a subject beyond that of an average person, sufficient that others may officially and legally rely upon his opinion. In general, witness may only give evidence of fact, whereas expert witness will give opinion based upon the facts. Hence, expert is not a witness of fact. He is a person who is going to give opinion based upon the facts. Hence, my dear friends, many a time the court considers expert witness is advisory in character. That means the real function of the expert is to put before the court all the material facts together with the reason which induce him to come to a conclusion, so that the court, although not an expert, may form its own judgment by its own observation of those materials. That means the expert witness will explain the facts and how a certain issue has occurred and how to draw inference. And in this process, the judge, that is the court, will come to its own inference based upon the facts and logical explanation given by the expert witness. Here, the duty of the expert witness is to furnish the judge with the necessary scientific criteria for testing the accuracy of the conclusion, so as to enable the judge to form his independent judgment by the application of these criteria. That means the expert witness is not going to give any judgment. Here, he is helping the court based upon his experience, education, logical explanation, based upon the facts available. He will help the judge to come to a conclusion. In this process, the judge may decide based upon his own inference. The credibility of such witness depends upon the reasons stated in support of his argument or conclusion, the data he has used, the material furnished, and also many a time, if he is able to look into the other aspect against his conclusion, the court will definitely appreciate that. That means this expert witness is unbiased. Now let's look into what are the standards applied for expert witness. There are two important criteria have been used. One is Daubert standard. This is used by a judge to make a preliminary assessment of whether an expert's testimony is based on reasoning or methodology that is scientifically valid, peer-reviewed, published, accepted in scientific community, and can adequately be applied to the fact of an issue in the court of law. This is the important standard which arose in a US court. There are two important criteria. One is Frye criteria and the other one is Daubert criteria. Frye criteria is a very old one. In this, in a simple words, it is based upon if the evidence is allowed into the courtroom, if it is generally accepted by the scientific community. That means if all the majority of the sciences says, yes, we accept this, then the court will accept. But there is no scientific temperament here. It is based upon the peer review, most probably. Although there may be no scientific data or logical explanation. Hence, it was challenged. And in Daubert case in 1993, the US court clearly said that there should be scientific temperament, there should be methodology, whether the error is acceptable. That means it is completely scientific in nature. Now, let's understand how this Daubert standard came into picture. This is based upon a case called as Daubert versus Merrill Joe Pharmaceuticals in 1993. In this case, the question was whether or not Merrill Joe Pharmaceuticals owed damage to children born with birth defects, allegedly because of the mothers have been taking a drug called as Benedictine during pregnancy for nausea. That means if the children had developed some congenital anomalies because the mothers had taken Benedictine, a tablet for their nausea during pregnancy, should this Doe pharmaceutical should be sued or not was the question. In this case, there was no data was available, but the parents and the children approached the court. During this case, the court came into very important conclusion and they formed it as a Daubert standards. And they said that when you want to consider as an expert opinion, there should be a methodology scientifically approved to be used to arrive in an opinion. That means you need to have a good scientific methodology. And that technology, if we are using something, has to be subjected to peer review and publication. Further, there should be a logical explanation, reliability, sensitivity, and specificity. Further, whether there are any possible errors, merits of the scientific methodology should be available in the public domain. Finally, the universal acceptance of standard across the scientific community should be considered. Based on that, Daubert standard has been considered as a gold standard for expert witness. There was a case even in India when a lie detection test was questioned. Unfortunately, the publications were very minimal. Only there were chapters written, and the company started selling those instruments in the name of lie detection. And invariably, Daubert standards, if we use, there was complete fallacy in that lie detection instrument. Now let's move into the expert evidence. What should be the characteristics? The first test is expert's educational background. Does he have a good educational background with the issue in the court of law? Does he know about it? Does he know what is the scientific issue involved? Whether he is qualified in that area? Whether he had any publication? How many years of experience? Plays a crucial role, and what he brings to the table in the court of law. The third test is readiness to the detail of his techniques, procedures, logical explanation, and also ready to withstand the scrutiny of the cross-examination. Further, the conclusive test that an expert is conservative, cautious, willingness to help the court with the scientific advancement, scientific temperament, and logically deducing his conclusion and explaining to the court of law. In simple words, does the experts have proper education, training, license? Has the expert practiced in the field of area which is questioned in the court of law? Has the expert performed similar investigation in the past? Has the expert provided testimony on the subject matter previously? So, my dear friends, expert witness means, by the virtue of his education, profession, publication, experience, is believed to have a special knowledge of his subject beyond that of an average person, sufficient that others may officially and legally rely upon his opinion. So, now the court has accepted it. Now the question is, what is the evidentiary value of a psychiatric expert opinion? As per the Indian Evidence Act of 1872, Section 45, and also the newest legislation, Section 39, clearly said that it is a corroborative evidence. An expert witness is not the witness of fact, and his evidence is really an advisory in character. That means it is an opinion. It is not the matter of facts. Now the question is the court bound to accept the psychiatrist expert opinion? In this regard, one of the landmark judgment, the Honorable Supreme Court has answered this question. And it said that a court is not bound by the evidence of the experts, which is to a large extent advisory in nature. Of course, many of the doctors may be angry regarding the observation of the Supreme Court. But please remember, nowadays, both the parties will bring their own experts. And invariably, both the parties will pay money to those experts. And these experts invariably will give opinion in favoring their client. That means, nowadays, the truth is sold in the court of law. This is unfortunate. Why is this? Many advocates would like to choose those experts who are going to give opinion in their favor. If there is an expert opinion which is contrary to them, they will never produce it in the court of law. Is it what the justice we are looking for? Unfortunate, but that is the truth. But however, in this regard, the Supreme Court was very, very categorical, and it knew that many of the expert opinions are being sold by the advocates. That means their opinion have been bought so that they can win the case. Hence, the court has clearly said that the court have a full power to derive its own conclusion upon considering the opinion of the experts on both the sides. Hence, the court has all the power to accept, admit, or deny the expert's opinion. Just because you brought an amazing expert's opinion doesn't mean that the court has to accept. That means it is left to the court, based upon the facts, the chain of events, whether this expert's opinion fits into that or not. Based upon that, the court will decide whether to accept the expert's opinion or not. That means it is just a corroborative evidence. Now let's look into the process in the court of law, how the expert witness is brought and how he behaves in the court of law and how he should respond to the court. The first is, the expert witness has to testify in the court of law under oath. Once he takes the oath, there will be examination in chief by the advocate who has summoned the expert witness. Once he does that, there will be cross-examination by the opposite advocate. And if required, the re-examination by the advocate or the court who has summoned them. Many a time the question can be asked by the court itself. Finally, the evidence, whatever has been collected, the expert has been deposing, has to be signed by the expert in every page and submitted to the court of law. But in this process, you please remember, just because an expert has given his opinion in a piece of paper in a hospital or maybe outside in his private practice doesn't mean that that certificate is considered as an evidence. It will never be considered as an evidence unless the doctor who has given that certificate should come to the court, take oath, recognize his certificate, his signature, and he has to withstand the scrutiny of the opposite advocate, and then only it will be considered as an evidence in the court of law, and later the court will decide whether to accept that evidence or not. Further, section 45 to 51 talks about Indian Evidence Act. Hence, I am very, very clear. The expert's opinion is only corroborative evidence. It is not a substantial evidence. So, if the court does not accept your expert witness, don't become angry and frustrated. It is the judge who knows the case thoroughly and considering the facts from both the sides and based upon your opinion and maybe in another expert opinion, he will come to his own conclusion, my dear friends. So now let's move into psychiatrist as an expert witness, specifically speaking from the psychiatry angle. We need to understand the challenges with regard to psychiatry in the court of law. The psychiatry being inherent nature, it is a disorder of thought, disorders of emotions, disorders of behavior. That means the person with mental illness, invariably, majority of them have invisible signs and symptoms. Even the disability is invisible. Hence, the court, maybe the general public, think that he is normal. And invariably, there are no blood tests, no CT scan, MRI scan, which will positively detect a person is suffering from psychiatric disorder. That means it is based upon clinical examination by a psychiatrist. That means an expert witness as a psychiatrist should do a thorough history taking, clinical examination, mental status examination, cognitive function, ward observation. Based upon that only, he has to give his opinion. And his expert opinion should be thorough, because once he gives an opinion telling that this person is suffering from mental illness, that means he will undergo severe stigma and discrimination by the society. Many a time, a person with mental illness would like to proclaim that he is bad, not mad. Although he is suffering from mental illness and he has committed a crime, he would rather say, I am a bad person, not a mad person. The reason being, the poor insight into their illness. Majority of the mentally ill person believe that they are normal and they refuse treatment. They refuse to take help. They refuse to take insanity defense. Further, psychiatric illness is highly dynamic in nature. They are chronic, episodic, remitting, relapsing illness. There are too many factors are involved. Today you may say, this person is suffering from mental illness. Maybe after 1 month down the line, after taking medicine, he may become normal. And 3 months down the line, he may stop the medication and there will be a relapse. Many a time he may be taking medications because of severe stress and also poor quality of medicine. He may have a relapse of symptoms. And the persons with mental illness, sometimes they may become risk to self, that is, attempt to suicide, death by suicide, or may they become violent against other people, homicidal ideas, destruction of property. Hence, the risk assessment becomes a part and parcel of expert witness, especially in criminal cases. Further, a psychiatrist should be aware of dual role biases. That means he is acting as a clinician to that person by treating him. At the same time, when the court summons him, he has to become an expert witness. That means, now the question is, in the court of law, is he a clinician to that patient or is he an expert witness? As a clinician, we have taken an oath. We will not do anything against the patient. That means, whatever we will do, will be in the benefit of the patient. That means we are not supposed to give a certificate or tell something against the patient in the court of law. In such an ethical dilemma, should we support the justice or the ethics is a big question. Hence, this dual role dilemma should be kept in mind. Hence, especially in US, the treating physician or a clinician or a psychiatrist will never be called in the court of law to give forensic opinion. Hence, the clinical psychiatrist opinion is different from a forensic psychiatrist opinion. Invariably, the court wants the forensic psychiatrist opinion. Although the clinician may be called as a general witness, his expert opinion will be given less weightage. Especially in India, the forensic psychiatry training is hardly 2 weeks. In the 3 years of MD course, that means we do not have forensic psychiatrist in our country. Above all that, the training of forensic psychiatry in many of the institutions is very pathetic. That means they do not have forensic psychiatrist specialist in that place. And we do not have MD or we do not have DM forensic psychiatry in our country. Further, there is no immunity for expert witness, especially in the forensic psychiatry. It is based upon clinical observation, based upon his experience, based upon his logical understanding, word observation. He has to give opinion. Further, in our country, there is no research with regard to forensic psychiatry. Whatever the research is occurring, either it is in the National Institute or else by a passionate forensic psychiatrist who are hardly in single digit in number in our country. Further, there is no motivation for practicing psychiatrists to learn and update regarding forensic psychiatry. The main reason being is going to court is an harassment, untimely summons, and you have to go and wait there. Examination, cross-examination. Many times it is humiliating to the psychiatrist. Not only that, their record keeping is also very poor. They have not been trained in that, and the remuneration paid for forensic psychiatrist is very minimal. Hence, none of the private practitioners want to become a forensic psychiatrist. And also, there is no training center in India apart from in NIMANS. We have a postdoctoral fellowship for forensic psychiatry, that is 1 seat per year. In the past 12 years, the most of the forensic psychiatrists who have done the PDF, they have left to abroad. The reason being, there is no monetization in India. But the question is, should we monetize? However, there is another side of the argument. Most of my students who have left the country, they say they do not get adequate remuneration in India. What does it mean? When they have to give expert opinion, They have to go through the file. They have to do the examination of the patient, family members, collect all collateral information. He need to take time to drafting the certificate. Whenever the summons comes, he has to go to the court, discuss with the lawyer, and wait for his turn. And the court may call him 2 times, 3 times. Many a time the opposite lawyer would like to postpone the case and making the expert to come back again and again. And the patient party will not be able to pay for the opinion, the time spent in discussion, the time spent in traveling, the time spent in waiting in the court of law, and the adequate remuneration is not paid. Hence, this hardship and the emotional turmoil and the frustration they go through, many of them, even they know about expert witness, they refuse to be an expert witness, and many a time they become hostile in the court of law. Now let's discuss about the general guidelines for a psychiatrist in the court of law when they become an expert witness. Every psychiatrist should follow this important principle. The presumption of sanity is a legal presumption. That means every person who walks into your chamber, consider them, they're all sane. They are normal people. That's the first dictum you should understand. Further, its effect is that a person who faces litigation or trial is presumed sane until proven. That means you need to consider every person is normal. And then if you say that he has schizophrenia as a psychiatrist, then you need to have evidence to back your argument. That means you need to collect evidence telling that he's having schizophrenia or to tell that he does not have schizophrenia. That means you have to admit and observe. Hence, avoid making diagnosis in the initial stage of evaluation. Read all the accompanying letters. When the patient comes for evaluation, make sure what is your job, not only based upon the court letter. Many a time, even the court, when they ask, many of the judges do not know what they need to ask. Whether they are asking for fitness to stand trial, whether they are asking for insanity defense, whether they are asking for fitness to execute death penalty, whether they are asking for whether the person can be rehabilitated, whether this person is a risk to others if the parole is given. So many of the time they do not know. They will say, please do mental examination. Hence, you need to talk to the lawyer, know at what level the case is there, and then you have to do the examination based upon the available facts. That means, although you have got a letter, make sure what is your job. Further, do not have any prejudice about the case. Go with the open mind for an assessment. Do a thorough general physical examination, mental status examination, ward observation. Please keep a photo ID or the identification mark. Do all possible investigation, urine for substance abuse. The main reason being, in prison, the drug abuse is very high, up to 30 to 40%. If the court is asking for a certificate within next 4 or 5 days, and you require time, please request the court that you require more time. The reason being is when the patient comes from prison, he'll be accompanied by the escorts. They do not know anything about him. You need to contact the family members, collect all past treatment details. You need to observe him in the ward. You need to do serial mental status examination. And then you have to give opinion. Hence, request for extra time. Don't hesitate for that. Make sure that all the notes in the file, that is the junior resident notes, nurse notes, senior resident notes, the junior faculty's notes, should be in sync. It should not be whatever they want to write in the forensic file, they write it. That should not happen. Please monitor who has access to this file, what they are writing in it. Collect all possible information from multiple sources. I would rather call it as a collateral information. It can be FIR, it can be social background report, forensic report, court papers, photographs. Call the family members. Many a time, looking through the internet, social media, checking whether this person, what kind of person is depicting himself in the internet or in the social media, interview the family members, friends, colleagues, talk to the advocates, investigating officer, other witnesses. If required, go to the site of crime. I would encourage all the expert witness even to talk to the victim's family members. That means you will get a view from the other side. Many a time, at this point of time today, in India, we have many rights for the accused. Unfortunately, we have forgotten about the rights of the witness, or sorry, rights of the survivor or the victim. We have n number of rights have been enumerated in the Supreme Court and the High Court with regard to the accused. But unfortunately, the rights of the victims and the survivors have been forgotten long back. This is an unfortunate. We do not have people fighting for the rights of the victims, hardly few people. But there are huge number of judges, rights activists fighting for the rights of the accused. This is the current scenario, my dear friends. However, the forensic psychiatry expert witness revolves around the proper documentation of serial mental status examination, serial cognitive function, serial MMSE, and serial ward observation. Based upon this, you will be able to answer logically, firmly in the court of law. Now, once you have done the examination, how do you draft the Psychiatric Forensic Certificate? Whenever you are addressing the court, please address the court. Don't write the judge's name. This is not a personal letter. Please write the letter addressing the court. And your report should be in simple words. Avoid ambiguous word. Write the information required to the point. Avoid technical words if you have to use it. Please do give meaning of those technical words. Explain it logically in your certificate and justify your findings. Signature with name. Copy should be kept in the file and another copy to the court has to be posted. Now let's discuss about how to prepare for the court. Whenever you get a summons, invariably it will be untimely. You are preparing for something else and suddenly the police will stand in front of your chamber and say, "Sir, you have got a summons, tomorrow you have to arrive." The reason being is either the police are insensitive or else they are also overworked. Many a time they postpone sending the summons. There are few intelligent police officers, as soon as they get summon, they WhatsApp or they will contact by phone telling that, "Sir, you have got a summons, I'm sending this through mail." So you get inadequate time to prepare for the case. Many a time, the police do not serve summons at all and suddenly they will come with the arrest warrant telling that you have missed the court. And many a time, the expert witness becomes highly frustrated because imagine you are going to an expert and asking, "I have an arrest warrant at the first instance." And the court does not do anything about this. Hence, many of our experts do not want to become expert witness in the court of law. This is the truth. We have to change this. Otherwise, we are not going to give justice for the victims or the survivors. And invariably, the accused will walk away with high head telling that he has done it and nobody can do anything. Hence, whenever the police comes with the summons, talk to him, take his number, check which court it is, take the advocate's number, the case number, patient's hospital file number, try to trace the medical records, because many a time, the police who comes is a third person. He does not know anything much of the case. He says, "This is the summons only, sir." He does not know when the patient was admitted in the hospital and he does not have any hospital records. Now, the expert has to find this or he is the accused. He has to find that. And invariably, many a time, You may not be able to find the file records because in a big hospital or a tertiary hospital, there will be at least 20 to 30 lakh files. Hence, you have to go through the medical records, find those medical records. Once you identify that, check and verify the father's name and also photo ID. Make notes, check for the other treatment he has taken in the past. If possible, seek help from your seniors, forensic psychiatrists, legal experts. Do not shy away from seeking help. No need to be anxious because you are not on trial. You are an expert. You are going to give an opinion and make sure helping the court in forming the right decision so that the justice is served in our community. Now let's look into the tips for responding the court. Whenever you go to the court, please know which court you are going. Dress appropriately with the formal attire. As soon as you go to the court, report to the court official or to the summoning advocate. Tell them you have arrived, have got all the medical records, and if you have to talk to the advocate, please talk to them. See what is the case, what are the questions he is going to ask, what are the caution you are to be in the court of law. Whenever there is a examination in chief and cross-examination, listen to the question carefully. If you do not understand the question, ask the advocate to repeat the question. If it is a very complex question, ask him to make it very simpler. Do not hurry up and try to give answer. Many times, few of the advocates are very intelligent. They want to make mistakes from you. They want to introduce certain words into your mouth. So you have to be very careful. And whenever you speak, wait, think. If you want to look into the file, go through the file. If you want to look into the textbook, go through that and tell the court that I have taken oath to tell the truth and to help the court as an expert witness. Hence, think and respond. Whenever you are addressing the court, say sir. That is, address the court by sir. If it is a madam, you can say madam. Or else you can go with our old British colonial, your honor. That is also fine. But I prefer to use sir. In case of difficulty, look at the magistrate and say, I am unable to understand. Please help me. Do not become emotionally charged. That is what the opposite lawyer wants. He will try to provoke you. And once your emotions are very high, you will give wrong answers. Hence, do not get upset with certain questions. Whenever there are tricky questions, think, ask the lawyer to repeat the question, and then answer. Remember, you are an expert here. You are not on trial. You are giving your expert opinion. Hence, it has to be the best. And remember, your expert opinion is a corroborative evidence. It is not a substantial evidence. And whenever you are giving percentage, range, and statistics, be damn sure about this. Don't give based upon your experience. There are many cases when the experts have given a wrong statistics and the case has been lost. If you want to use statistics, you quote the statistic from certain textbook or from certain scientific literature. Do not give any percentages just because of your experience. Don't do that. Because the opposite lawyer would have come with the textbook, scientific literature, or else he may also would have taken another expert's opinion. Hence, my dear friends, don't ever give some percentages, ranges based upon your experience. It has to be scientifically validated. Carry medical records, carry textbooks if you want, carry DSM-5 or ICD-10. Any forensic book, if you think it is useful in the court of law, carry them. Switch off your mobile phone once you reach the court. And once you have deposed, sign all the evidence pages. Date it. Ask for attendance certificate because you attended the court. The reason being is you are a psychiatrist. And something goes wrong in your hospital. And if that patient goes to a court of law, you can say, I was attending the court, and that certificate is very essential. Hence, whenever you attend the court as an expert witness, don't forget to ask for attendance certificate. Another important tip I would like to give you: do not fall into the trap of the opposite lawyer or an advocate who says such questions in psychiatry. Is there a possibility that if another psychiatrist examined this case, he or she would have come to a different diagnosis than you? That is a trap. In psychiatry, that is a possible. But you need to be very clear. You have to say, in this case, it is not possible. The reason being is this patient was admitted. I have examined him for so many times. So many serial mental status examination has been done. So many cognitive functions have been done. Ward observation has been done. And I'm very clear. Either have examined or any other psychiatrist has examined with the same effort, invariably it would have been schizophrenia. That means don't fall for this trap. Further, many of the opposite advocate will trap you in this yes or no question. Many a time, especially if you are going to a court as an expert witness, the lawyer will say, is it schizophrenia curable or not? Answer only with yes or no. This is a trap again. If you say schizophrenia is curable, he may provide a literature telling that schizophrenia is chronic. That means it cannot be answered yes or no. Invariably, these advocates will be shouting at the top of your voice so that you commit something. At that time, you have to be careful. You have to keep your peace of mind. Do not fall into the trap. Look at the magistrate. Look at the judge and say, sir, I cannot answer this question on yes or no. Invariably, the advocate will shout at his top of his voice and says, answer it in yes or no. Look at the judge and say, I can't say this in yes or no. I request the court to give permission to explain this so that the justice is not aborted. If he continues to shout on this top of his voice, say, I cannot answer this question. Let it be documented, because you have taken the word to tell the truth. Here, the opposite advocate is using his privilege to trap you. Don't fall for the trap. Many a time, even these advocates will attack your credibility because they want to make your expert witness weak. They may ask how many times you attempted to pass MD exam. They may ask your caste. They may ask your maybe which part of the geography. They may say you have failed 10 times. Many a time they'll say you have taken money to give this certificate. That means they would like to put dent into your credibility in the court of law. Don't become angry. Answer coolly and be confident in the court of law. Many a time, if you do not know or any specific issue you are not examined, tell the court, I have not examined in this particular issue. I need extra time. Please send the patient for examination. Being open, admitting your mistake is good. The court also knows you are not a god. You are a human being. You are an expert witness. Here, you are helping the court. Do not make mistakes. Do not do deliberate errors. And be careful whenever you are making conclusion based upon the notes of the nurse or any other doctor. You have to stand your opinion based upon your examination and your notes, or else you have dictated the notes from a junior staff. That you have to rely on. And if the doctor or the advocate asks, what is this? Some doctor has written something. You have to tell the advocate, I'm here to depose whatever I have examined. If you want me to read and explain what the other doctor has done, I am ready to do that. But today I am standing here as an expert witness based upon my observation. Finally, my dear friends, I'll be discussing some of the legal issues with regard to expert witness. There are cases in India where the patient has challenged the psychiatrist's diagnosis in the court of law. During that time, the psychiatrist can be pulled into consumer court. They may give a complaint in state medical council telling that this psychiatrist has given me a mental illness certificate. And in this regard, there is no immunity given to psychiatrist. Even if you have deposed as expert witness, They may pull you into compensation case. Suppose if you are not trained in forensic psychiatry, but you have worked for longer duration, be confident and tell, I have not done the forensic psychiatry, but by the virtue of so many years of experience, by virtue of teaching law, by the virtue of seeing giving opinion, I have attained this forensic psychiatrist status. Well and good. Don't tell lie in the court of law. Hence, expert witness has a special place in the court of law, my dear friends. Your skills, your experience, your knowledge, your wisdom should help the court to deliver justice. And unfortunately, the court also knows there are many hired expert witnesses who, for few amount of money, they will depose in favor of their client. The simple reason is the client will pay only. The witness is giving evidence in his favor. And many of the court knows about this. Hence, this kind of bias is a systemic in nature. And because of the corruption which is pervading in the advocates, invariably the advocates will choose those experts who are going to talk in favor of them. And invariably, they will choose the experts who will fire in favor of them. So you have to be very careful. You have to tell the truth. You have to give the scientific evidence and help the court to come to a conclusion which is in favor of justice. Do not give opinion just because the client has given huge amount of money. There are cases in India where the patient has challenged the psychiatric diagnosis. There is no immunity for psychiatrist in the court of law. If you have not been trained in forensic psychiatry, there are chances that psychiatrists can be sued in the court of law, my dear friends. But however, there is a rescue clause. Section 105 of Mental Health Care Act clearly says that whenever there is a question of mental illness in judicial process, that means if there is a case in the court of law and there is a challenging regarding the diagnosis, this section 105 will come into rescue clause. That means if during any judicial process, before any competent court, proof of mental illness is produced and it is challenged by the other party, the court shall refer the same for the scrutiny to the concerned board. And the board shall, after examination of the person alleged to have mental illness, either by itself or through a committee of experts, submits opinion to the court. So you can tell the court, sir, I am just a clinician. As per Mental Health Care Act of 2017, Section 105, this statute clearly says the court has to refer this to the Mental Health Review Board and the Mental Health Review Board will form its opinion. Hence, you have to request the court to refer the case to the Mental Health Review Board. To conclude, my dear friend, psychiatrist expert faces many challenges in the court of law, especially with regard to expert witness. The reason being, psychiatry is very unique when compared to other medical field because there are no lab test, CT scan or MRI positively to diagnose mental illness. The evidence of psychiatric expert is not a substantial evidence, it is a corroborative evidence. Hence, be very clear when you are deposing in the court of law. You need to do a systematic assessment, thorough documentation, ward observation, serial MSc, cognitive function, and then only you have to give opinion. Be aware of your dual role biases. You may be a clinician also, you may be expert witness also. But when you go to the court of law, you are not supporting either the client or the patient or the opposite party. You are helping the court in delivering justice. But please remember, if you are supporting your patient, then the opposite party can pull you in the consumer court or may go to the court telling that you have deposed under oath wrongly. That means there is no immunity given to the expert witness, especially in US and UK. And hence, whenever you feel that Section 105 of Mental Health Care Act of 2017 has to be used, please educate the court telling that it has to be referred to the Mental Health Review Board. And do not avoid seeking help from your seniors, forensic psychiatrist, and legal expert. Please seek help. Here, in expert witness, you are not on trial. You are an expert giving opinion. Thank you very much for giving your valuable time. Stay safe.